Y'all can all stay seated. Y'all want to tell me what we're working on today?
Your Honor, with the court's permission, I'd like to introduce myself. Ricardo Cedillo. I've been on the pleadings, but I've been in jury trials in 2 different states since the proceedings began. So I'm here today, and I want to introduce myself. And I want to tell you guys that I came bearing gifts. If I may.
Lavish gifts.
Lavish gifts, Your Honor. If I may approach.
Amen.
Your Honor, this morning we e-filed an anti-SLAPP motion under Chapter 27, I think. And we have a courtesy copy to the court that I'd like to leave with you. Obviously, it's not on the docket for today. And then these other notebooks, Your Honor, we've assembled the case law and the citations there for you, and we put them out of the order. And it ended up taking 2 big notebooks. And we've provided the opposing counsel, of course, with a duplicate set of what we're providing for you here. And I don't know how many anti-SLAPP motions, the statute's only a year or 2 old.
It'll be a first, so.
It'll be a first, and, you know,
They've got that much case law.
yes, it does, actually. But it's a good thing to kind of peruse through as you're watching Cowboys beat the Eagles this weekend, or, you know, for your reading pleasure. It's actually pretty fast reading. I think that if you devote maybe an hour or so for the body of the motion, the case is finished. It is something I think that
We're going to try to set that at that same date in December or something like that.
Well, Your Honor, the one aspect about the motion is that, although it's got some leeway in it, you're supposed to act on it within 60 days. So the legislature built a short time on it. But of course, if your docket doesn't allow it, there's provisions for that. And then I think there's a 30-day turnaround after you hold the hearing. So that's just one of the aspects of it. But when I introduce myself, I like to leave an impression. Here it is.
Very well.
Or can I put this down for you?
Oh, this is right.
Right there, good. Your Honor, one other point on that, and I conferred with Mr. Capuccio. We left a message with Mr. Ray this morning after we filed it. Under the terms of the statute, all discovery is supposed to come to a screeching halt. The case is supposed to come to a screeching halt once the anti-SLAPP motion gets filed. We are not taking that position. And I don't know if we have to formally get an order to you to allow it, but what I've told Mr. Capuccio is that the parties have been cooperating, working towards getting the jurisdictional discovery on the special appearance. We're going to keep our word on that. We will proceed and get what the parties have been working towards accomplishing on the special appearance, so that you can go forward with the special appearance. We're not taking the position, although literally the statute says you're supposed to shut it down. We're okay with you not shutting down the jurisdictional portion of the discovery, which is what we've all been working for. I've read every transcript. I know all the work that's been done. We're not setting any of that work aside. We're going forward with all of that to the extent that the parties are working on that.
To the extent that any discovery is being sought goes to the jurisdictional issue.
Yes.
I would think we need to continue that. Otherwise,
Technically, the statute says even that's supposed to shut down, but we're not taking that position. We're taking the contrary position. We're going forward with what the parties are working on.
very good.
And then, Your Honor, from a little bit more housekeeping, from the previous meeting we've had with you, the court reporter requested that we submit certain excerpts of videos and so forth to make the record. And we have marked them as defense exhibits 1, 2, and 3 with our cover letter of transmittal, and we'd like to provide that to the court reporter on the record now.
Ray, and myself. Greg, are those some of the videos that were previously played? Is that what we're talking about?
They were played during the
DVDs?
September 12th hearing in this matter, Your Honor. And at that September 12th hearing, it was indicated to the court that we'd be providing copies of those clips so that they'd be included part of the record. And that's what we're doing now. And I want to do it on the record.
Very good. Get Kendra to Mr. Ray.
Guys, what I'm doing here?
I obviously haven't reviewed those, Mr. Ray, but I'm presuming those are copies of what was in fact played. I can't verify that. Y'all want to try to verify that?
Yeah, I think we need to look at, they did give them to me today for the first time. I need to look at it and see if they match up. And we're gonna have ours to tender as well. So I think we probably will hold off on offering the evidence now. We have to object to the same action.
Your Honor, as an officer of the court, I can represent to you that that's an exact copy of what was played. I just want the record to reflect that we.
But I'm not going to force them to make a ruling, or make an objection.
No.
So they've had opportunity to review what was done month and a half.
I agree that no objection has been waived. They reserve their right to object after they review it to their pleasure. I just needed on the record to show that I brought forth what we said we'd do on September the 12th. And they can reserve their right to look at it, object later. I'm fine with all of that.
Somebody remind me at a later time to make the ruling.
Thank you, Your Honor, and we'll do the same. We'll
Within a
tender.
reasonable period of time, let me know if you've got something to check.
Thank you.
Your Honor, if the court's ready, I believe we're now at the point of taking up the two motions that are actually set for this morning. And the first of those, I believe they're courtesy copies up on the bench. Yes, sir. The first of those, I believe, is on top, and that's for entry of a confidentiality and protective order, which is with very slight modifications. The confidentiality and protective order is an exhibit in the local rules of the United States District Court for the Western District of Texas. The motion describes about half dozen changes I made in that. For example, I made a reference to the federal rule of evidence to change it to the corresponding Texas rules of procedure, change some typographical errors, and have submitted that. In getting ready for this morning, it's my understanding from opposing counsel that the sole and exclusive disagreement they have with the form of that order is that if you look, you have the order attached to the motion.
Yes.
And on the first page of it, there are paragraph number 2, it talks about qualified persons and describes for the two categories of classified information, first being counsel or attorneys only, and then a second category B, this is on page 2, for confidential information. The only change plaintiffs are requesting is that in 2, or that's, double lowercase I, B2, they want to add the words or the party's spouse, or and the party's spouse to that. The request, of course, is that the plaintiff's husband, Mark Rathbun, would be permitted to see this confidential information in the case, and we totally oppose such a change. The basic rule, the model rule, the one that we've been working on, contains no such language. There is no provision in the federal model rule on this, model order, that permits a spouse to look at any type of classified information. There is no need for the spouse to look at classified information. What this is an indirect way by the plaintiffs to try to get around the fact that they do not want to designate Mark Rathbun, who is the plaintiff's spouse, as a consultant or an expert because of course if they do that, they're going to have serious problems with the issues in the other motion that's set before you this morning, which is to restrict Mr. Rathbun's revealing confidential information. In fact, in your order your 8-page order I believe you signed it on September 30th and it's filed on October 1st. But in your 8-page order denying the motion for disqualification, you pointed out that there was no evidence before you that Mr. Rathbun was serving as a paid consultant in this case. That under the record before you, that was not shown. They don't want to have to designate Mr. Rathbun as a consultant. If they did that, because if you look back at the first page of the order of consultants and look at classified information, they don't want to do that. They want to do an end around on it by adding this spouse language. And it is simply inappropriate. It's not in the model order. And we very much request that it not be added in this case.
Yes.
Your Honor, you've had before you since 5 or 6 weeks the affidavit filed by Mr. Rathbun. And in Mr. Rathbun's affidavit, he describes in detail an entire structure and a series of mechanisms and protocols done by these corporations to make sure that no one can find out what it is they're doing when it comes to matters like the harassment of Mrs. Rathbun. They've provided no evidence to the contrary. And so what they're saying is this highly secretive organization that works day after day to make sure that their activities aren't discovered. I'm talking about tortious and criminal activities are not discovered. What they want to do is to produce to Mrs. Rathbun, who's never been in the Church of Scientology and has no knowledge of it, and her attorneys who have never been in the Church of Scientology. They want to produce the documents to them, but her husband cannot look at them. He's the one that understands how things work within this corporation. That's not anything confidential, and I'll point out to the court once again that every motion they ever file, every argument they ever make in court, they never tell you what this confidential stuff is. Now, I'll remind the court that this format that we're in agreement with, this format of the Western District of Texas, although it's called a protective order, it doesn't actually rule that anything is confidential or protected. It just sets up the procedure. Corporations give up the documents. If you think they're confidential, you stamp them confidential, and this is how the plaintiffs will treat them. If the plaintiffs don't agree that they're confidential, the plaintiffs will call them on that, and then they have to come to court and convince you that it's confidential. So one thing I just want to make clear and be a reminder of is there's nothing here identifying or getting you to rule that any particular thing is confidential. And now we've been through all these lengthy hearings, they still never told us what anything is that they claim is confidential. So, documents are going to be produced. Mrs. Rathbun is going to be able to look at those documents, and her attorneys are going to be able to look at those documents. We have no knowledge about exactly how the documents work within these corporations, but Mr. Rathbun does. So the other point that we made in our response to their motion for protective order is this. If the court will go and look at the answer that CSI filed in this case, it gives 7 pages of facts. And the interesting thing about the 7 pages of facts that support their defenses is they almost never even mention or refer to Mrs. Rathbun. It's 7 pages of attacks on Mr. Rathbun. So Mrs. Rathbun is supposed to prepare her defense to their defenses, for want of a better way of saying it, without being able to communicate with her husband and share with her husband the documents that they produce that supposedly will support all of these factual allegations they've made against Mr. Rathbun. So one of the things that we try to do with our response is to point out what is the beginning point from which we address all of these issues. And that is discovery in and of itself in any way confidential or to be hidden from public view, from Mr. Rathbun's view, or the press's, or anybody else's? No. There's nothing in the federal or the state rules of procedure that say that ab initio, from the beginning, there's any confidentiality about discovery. So moving for a protective order is an exception from the normal openness that we have in our courts. And we cited to and provided many quotations from the courts about the right of sharing. In fact, the Texas Supreme Court has made clear in Texas we have a doctrine that documents produced, even where there's a protective order, a plaintiff's counsel can share those documents with other current or future litigants against those same defendants. So our point is this. They have an obligation to show the court under the rule on protective orders. I've looked at so many rules lately, the 192. Under the rule on protective orders, they've got to come in and show you that they need this protection. We have no problem with setting up a procedure for how we deal going forward. We just have a problem, and we announced this in court the last time we were here. We're fine with doing it, but our problem is excluding Mr. Rathbun from being able to help his wife as she prepares her case. They can characterize it, though, what our motivation is. We don't want to name him as a consultant. We don't have any obligation. Mr. Rathbun is a fact witness, and he's the spouse of the plaintiff. Unless they show you some compelling reasons for why you should carve him out and keep him out of this, then he should be allowed to. That is, to have access to these documents and consult with his wife and her attorneys on this matter. So, there's a couple of things they've asked for that one of them, this asking, I can't quite figure out what is the motion in limine and what is the motion for protective order. I guess it's the motion in limine that says we can't talk to Mr. Rathbun, he can't tell us anything about his 30 years in the Church of Scientology, etc., etc.
Yes, sir, that's a separate motion.
Literally, their motions, at least what we've been given, say nothing about why they're entitled to this or what the specific information is. That's not really we have pretty liberal pleadings rules in Texas. It's notice pleadings. We're literally not on notice of what it is they claim is either confidential or what their justification is for doing this. Restricting Mr. Rathbun and Mrs. Rathbun and their attorneys from talking is a prior restraint on free speech, presumptively unconstitutional, and in essence what they're asking for is a gag order on Mr. and Mrs. Rathbun and the attorneys in this case. The other thing is, we have on file among the court records the affidavit of Mr. Rathbun. And they are, in essence, asking that that be sealed. They're saying that that must not be disseminated. Well, last time I checked, it's a public record on file with the court and available to anyone who wants it. If they want to ask for a sealing of records, they have to comply with Rule 76A. They haven't even made an attempt. Instead, what they've done is filed, just a plain vanilla motion that says particular information that needs to be protected. That's where we are, Your Honor, and we think it's a very important point, and there's no reason to exclude Mr. Rathbun from assisting his wife and her attorneys in this case.
Spencer, what was it on page 1? You suggested was a change, or is it just under?
Their proposed change is on page 2,
Okay,
and it would add,
but it's under.
It's under B, Your Honor, little Roman numeral 2.
they would add the words simply the party and her spouse.
The party spouse.
Here's our proposed language right there under B, which says the party and her spouse.
Your Honor, may I respond to the comments by Mr. Ray?
Yes, sir.
Mr. Ray says, what is the compelling reason? And it goes back, Judge, to what you wrestled with on the motion to disqualify. The compelling reason is that, and counsel is admitting it, their position is that Mr. Rathbun has specialized knowledge. He has that specialized knowledge because for 20 years he was head of the legal affairs of the company. All of the authority that Mr. Spencer brought before you on the motion to disqualify, all of that would kick in. His question identified with particularity or specificity the confidential information itself. Judge, the authority that you were given, I know that you looked at and you wrestled hard because that's a very thoughtful order that you presented to us. You're looking to do something short of disqualification. You're looking for the lesser measure. The lesser measure, Your Honor, is not going to be achieved if you allow them to end run and say, well, because he's a spouse, then we're not going to apply what should be applied under the disqualification and the irrebuttable presumption that someone in that position who gained that specialized knowledge by being in that position is someone that they ought not to be consulting with, and if they had, then they need to be disqualified. We asked for that. We understand your order. You said, give us a lesser measure. We're here with a lesser measure. And it is not a Rule 72 or a gag order type situation, Your Honor. You impose obligations of not communicating with spouses every time that the jury box is filled. What we're looking for is to keep something confidential under the order that the Western District, the form that the Western District has approved, which is what we're working on. The whole spousal communication thing, Judge, if you begin looking at it as a privilege, it works very, very differently. Spousal communication is such that you can't compel them to testify against each other. You keep that in confidence for that reason. This is a situation where they want to use spousal communication to render void the very protections that the Western District model order would be giving us. They're saying, you know, we really want to rewrite Section 2A because we're going to say independent experts and consultants, except that if you don't want to name an independent expert, if you heard Mr. Ray tell you that Mr. Rathbun has specialized knowledge, that's the definition of an expert, or a consultant, someone that can assist. What they're saying is, let's just call him a spouse, and it won't fall under 2A, because if it did fall under 2A, Your Honor, we're back to the motion for disqualification, and you're not giving us a lesser measure, and so we'd be insisting on the disqualification. The only way we can get the effective lesser measure that I think you were urging us to come up with is if you get the spouse not to be included. Now, let's make sure that we understand the fine line, Your Honor. At the end, or towards the end of his comments, Mr. Ray was saying, you know, he's going to be a fact witness. There are many factual matters that the spouse is going to be allowed or will be testifying on. And the Western District model order would in no way affect their ability to have the spouse's participation in those things. We're not trying to drive a wedge between husband and wife or to keep them from being able to you know, comfort each other or discuss with each other. On the factual allegations that are being made, the husband, I suspect, and I'm going to have a chance to cross-examine someday, on the effects of or manifestations of the alleged emotional distress. Certainly he's in a position to give fact testimony about that. This isn't what this order would be touching. It would be precisely what Mr. Ray has used in his examples to you. They'd want to use him saying, well, because of who he is and who he was and what he's done, he's in a particular position to be able to come in and help us. Well, that's under the authorities we argued last time, and I'm going to argue those again. That's what we were addressing last time. That's why he should not be. And that's why the disqualification would go forward. And I don't want to rehash all of that, Judge. You put an order together that said a lesser measure. If you include the spouse, then it's not a lesser measure at all. You're allowing them to have full access to someone because of specialized knowledge, which they shouldn't have because of the way he acquired it.
Your Honor, may I respond?
Briefly.
Your Honor, we too have read your order. Your order was not an order saying, hey, come back and get some kind of extra measures. Your order said that this same canard that they're arguing now does not apply to this case. This is the first sentence from your order. Each of the cases cited by CSI that establish the standards for use of either irrebuttable or rebuttable presumptions involved employees of law firms or litigants who for various reasons switch sides, if you will, midstream. Your Honor found that this whole area of just saying confidential, you know about what went on behind the scenes, and we don't have to show harm, we don't have to show that it's actually a trade secret or an attorney-client privilege matter. You have pointed out that those cases do not apply to our situation. So we did read that. The rules, the Texas rules specifically recognize that spouses are different from everybody else. Spouses are exempted from the exclusionary rule. The spouse can attend depositions. The spouse can sit in on the testimony during the trial. Mr. Rathbun will sign off on what everyone under the confidentiality order is required to sign off on, that he won't disseminate it anywhere. We're talking only about communications between Mrs. Rathbun and Mr. Rathbun and the attorneys for Mrs. Rathbun. So, once again, as I maybe inartfully tried to point out in my earlier remarks, you have pointed out we're not under those cases that say, hey, these corporations don't have to show that there's a trade secret involved or that there's something that the law recognizes as confidential. Those cases don't apply. So therefore, where are they? And we wrote to them a letter and said, if you have some materials that you have a concern about, you can identify them for us by category. You know how it is in the typical case. Pricing information, customer lists, blah, blah, blah. Well, you sent us away from here 5 weeks ago to go do some discovery. The discovery was some depositions and document production. By the way, they've responded to the document production and given us zero, not one molecule of production. And what they said is, we're not going to do depositions, we're not going to do document production, we're not going to do anything until we get a protective order. And if you remember the context of this overall case, it's a war by the Church of Scientology against Mr. Rathbun, and they included Mrs. Rathbun in that and attacked her viciously. This is just an attempt in the courtroom to continue that same war. We're going to attack Mr. Rathbun throughout this case, but Mr. Rathbun cannot look at any of the discovery materials we produce. They have not made a showing to you, Your Honor, under the good cause standard or any other standard, that this protection they're asking for, which is that Mr. Rathbun not be able to see these materials, is justified.
How would that work, Mr. Cedillo, when we get to trial and husband is allowed to sit in the case, he's a fact witness, and he can't, he's sitting at counsel table with his spouse,
Well, Your Honor,
can't talk about what some of the other testimony from other witnesses, including information about documents that may be in evidence,
well,
or
Your Honor,
that creates a very tenuous situation simply to manage.
Judge, it's a tenuous situation in any trial that is always managed. Because the spouse is allowed to sit in the courtroom and not excluded under the rule, that doesn't allow that spouse to go and tell witnesses that are coming up what is going on. He's excluded from the application of the rule, but he's still under it's an exception. The rule still applies to
I
him.
understand that, but I'm talking about then his ability to discuss things with his spouse, the party, and or the party's attorney.
But we believe, Your Honor, that
That's something that's not normally managed.
well, it's something that isn't normally managed, Your Honor, because normally in a spousal relationship, one of the spouses isn't someone that is filing affidavits, running the blogs, encouraging people to steal documents and bring them to him because he'll give them legal protection. I mean, Mr. Ray wants to turn every legal argument that we're having here into a jury argument. And we can do that too, okay? We're asking the court to focus on the standards for protection under protective order. That's a legal argument, Your Honor. The point that he's making about, this is an attack on Mr. Rathbun, Your Honor, this is Mr. Rathbun's attack on the church, which is consistent with everything he's been doing. He just so happened to use his wife this time as the vehicle for the attack, thinking that somehow he'd have the best of both worlds. He'd be insulated because he's not a party, and yet still be involved. If he was a direct party in the attack, Your Honor, we would be having this discussion about the protection within the confines of a protective order that would apply to him as a party, and the disqualification motion would take on a different flavor and a different bent. What he wants to do is circumvent all that and come in with an artfully crafted exception, loophole, if you will. But any way you look at it, Judge, it's a head fake. She is a public figure because she has been incorporated into his status as a public figure. And that goes to a lot of our defenses, of course, on the First Amendment issue, on the privacy issues, on the intentional infliction issues. We're in a situation, Your Honor, where we're the ones reacting to the battle that's been brought to us. They want to get up and cast themselves as the victim in all this, and they're not. He's practicing his independent religion. We have a First Amendment right. We have proprietary rights for our trademarks, perhaps copyright, that any church would stand before you and have the same position to advance. He wants to conduct a business out of his home where he practices independent Scientology. He wants to charge people money to provide those services, calling it independent Scientology. And he is the one that wants to direct this attack by using his wife and the allegations that we somehow committed torts against her to continue what he's been doing all along. And our defense is necessarily going to have to center on him. And the fact that he was who he was and did what he did and is doing what he's doing on his blogs and encouraging people to steal documents and bring them to him and offering them legal protection when they do, All of that, Judge, is part of what we have to contend with. And when that person wants to get in on a loophole to be able to continue doing this and looking at our documents so that they can end up on his blog or end up being something, that's not prior restraint, Your Honor.
Those are two different things, are they
Well-
not? I mean, my point is this, is that we're gonna probably end up with certain exhibits being offered that y'all have alleged and may have ruled that are gonna be found confidential.
Yes, sir.
Okay. And we're gonna have a trial, that's gonna be in evidence, and while that's in evidence, he's gonna be sitting there at the counsel table or nearby with this guy.
Well, Your Honor, I don't know that there'll be an evidence, number one. I mean,
Well, or-
depending on the document. And if it's something that's confidential and attorney's eyes only, and there's room for that document to never see the light of day in a courtroom. And I do this in federal court all the time. We go through a very elaborate process, and a lot of stuff is deemed confidential. If it involved the secret formula for Coca-Cola, Your Honor, or the kernels, herbs and spices for the chicken, and that somehow had to be revealed attorney's eyes only under a confidential order or protection, in discovery, they get to see that document with the spices and the Coca-Cola formula. That never gets introduced into evidence.
Well, or there's testimony relevant there too, maybe not, my discussion may be inartfully espoused, but my point is there might be some testimony relevant to confidential information, and so if it's gonna be out on counsel table, I mean,
Your Honor, my only answer, Judge, is that we got to deal with that when we're there. Depending on the document, depending on the circumstance, depending on what protections we can do.
or let's put it in the terms of a deposition.
I think it's the same procedure, same flavor, different ice cream cone, but we'd have to deal with it as it came up, Your Honor. I mean,
So does that, I'm going to introduce that, mean we stop the deposition at a certain point to say that a certain person who otherwise would be present under the rules has to be excluded for 15 minutes or something like that?
And we do that in depositions all the time, Your Honor, where we say, this is only for attorney's eyes, it's going to be attorney's ears. We designate this Q&A portion of the deposition as confidential, attorney's eyes only. The court reporter has to do that on the spot, and then we tell them when it stopped. In patent litigation, when we get to some trade secrets that were never put into a patent, I've had judges in federal court clear the courtroom, and we seal it for the federal procedure for that. But we conduct the trial, still respecting all those confidences. The Western Order is written, as a framework or a base, so that all of that can still be happening. Because, Judge, you can't be a little bit pregnant on this. If you disclose something and it's waived, it's waived. And so the order is to look at it for the protection. And I know it's not a very good answer to tell you you'd have to do it on a case-by-case basis. The practical answer is that that's done all the time, because that's the only way to do it.
You're not dealing, Your Honor, with normal litigants. They've established that over several decades. We sent them discovery in furtherance of the jurisdictional issues, to which they gave us no documents. And just to give you one example, we asked them, now mind you, this is the parties claiming that there's no jurisdiction over them in Texas and they do nothing in Texas. We asked them for documents or any documents or videotapes, etc., of surveillance they have done in the state of Texas. And they objected and said that was a trade secret. So what's going to happen, for example, at depositions is they're going to say everything is confidential. And so we'll constantly be having to run back here to court and getting the court to rule that, well, in fact, Mr. Rathbun, if that's the case, may sit in on the deposition, that that's really not confidential. This is a situation that is ripe for abuse by them, and I just think it is a reasonable and normal accommodation, given that the rules recognize that a spouse is different from other parties, and that Mr. Rathbun, if he is included in the protective order, will be subject to contempt of court, and will, or sort of referencing that maybe he'll stick these on his blog or something like that. No. This is purely so that he and his wife and her attorneys can talk about these things, and we can have the benefit of his experience. None of which is improper. Think about every product liability case against General Motors or Firestone Tires or the cigarette companies. Former company employees cooperate with and talk to the plaintiff's counsel and to the plaintiffs all the time. The only question is it about a matter that is a trade secret or privileged in some way? They still have not pointed to anything that is a trade secret or privilege and made that argument to you.
Well, I understand. And I've got the framework of the issue here, and I'll probably do a little bit of research on my own.
Your Honor, if you allow me one last thing to point out, the person you're hearing arguing, I'm not asserting a special appearance. His argument was that the people fighting jurisdiction are doing A, B, or C. You're not hearing from them. I've answered. I'm here.
But they are filing the motion for protective order on behalf of the specially appearing defendants. This is to cover all the discovery in the case.
Just very briefly, Your Honor, we did file a special appearance, and because we filed a special appearance, we're constrained in what all we could do, we can do in the positions that we can take without making it a general appearance. So that's the only reason why we have a limited involvement in the case at this point. And we hope that the special appearance will be sustained. I'm not sure what he's referring to in his complaint about our discovery responses. We'll obviously talk that's for another day. We're going to provide whatever documents we're going to provide on jurisdictional issues once there is a protective order in place that limits the dissemination of that information. And we talked about this the last time we were in front of the court, that we wanted to have a protective order in place before we proceeded with discovery. And that's why we're here today, because we couldn't work out the terms. But I just, very briefly on one last point, it's them who are asking for the exception. We're not asking for an exception from the form that's in the Western District. It's the plaintiff that's asking for an exception to the form to allow a spouse. That's a significant deviation from what is in the Western District form. And it's the reason why they're asking for it is clear. But we are in agreement, other than that one deviation that they are asking for in the form of the Western District protective order.
Okay. Like I said, I think I've got the framework. Again, what we're dealing with, is there some particular deposition or something, discovery that you can do on a short fuse? In other words, that I need to make a release?
Well, they won't give us any documents or do any depositions until there is a protective order framework in place. So that does make it slightly time sensitive.
Okay.
And the other,
Not a deposition set now, correct?
well,
You get the one
we may have
that
sent
was last week or 2 weeks ago.
Those got reset.
those are all right now. In fact, today we should be issuing all the deposition notices on them because we've been getting the dates from all the counsel. But the one clarification I would like from Mr. Cedillo is he said that they're not opposing the discovery that's already ongoing. Well, there are two depositions that have been scheduled and now are being rescheduled. That is Tommy Davis and Leah Rimini. Is that included in there, or do we need to fight over that?
Well, I haven't been part of those discussions, and I apologize that
Well, I'll probably let y'all have that
Yeah.
discussion.
What I was attempting to convey, Your Honor, was that we have been in discussions, and I believe that there are depositions that we've agreed, maybe we got to work on schedule or whatever. We're not trying to get those thrown out and get back to square one or any of that. If there are others that we are still I mean, the only answer I can give is that when he notices it, then we'll react to it. If it's, you know, when do you want to take Davis, we work out the day. I think we've given you dates for
Yeah,
Davis.
I think we have
we'll be
dates
fine
on all of the depositions. It's just a matter of issuing the notices, which we were gonna do today. So,
And there will be some, Your Honor, that we will agree with. There may be some, when I get his notices, that I'm reserving my right to react to those. My opening remark was only to make very clear that we are not taking the position that Chapter 27 would allow us to take, and that is that everything shuts down. We're not doing that. We've already agreed on the names and the times and the places of people. Those are going forward. If we have not agreed on the names and places and times of people, we'll continue discussing that. If we have to assert objections, we will.
I understand we have, is there another motion that we'll
Yes.
probably end up taking up after lunch, because I've got a bar meeting that I need to go to. I'm supposed to be available to answer questions, so it's really needing to go. But
There is an important motion that we do have set, and probably would be wise to take it up after lunch, or at the court's pleasure.
okay, well, I mean, this bar meeting starts here in 5 minutes, so I probably need to run a minute, so. We'll be back at 1:30.
1:30, sir. Thank you.
Your Honor, may we leave our things here?
We'll lock it up.
Thank you.
You're welcome to leave.